Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Welcome to this series of the Leadership Development Program of the American Bar Association section of Environment, Energy, and Resources, looking at the first 50 years of the Environmental Protection Agency, including the development and evolution of tribal relations when it comes to matters of environmental protection in Indian country. And a very warm welcome today to our listeners and to our special guest, David Coursen, an attorney working on tribal matters at EPA between 1987 and 1994, and returning again to work there between 2005 and 2009, during a critical shift to institutionalize the Indian program in a formal manner and recognize tribal sovereignty. He witnessed the creation of the Indian Environmental Law Office, handling issues spanning treatment as a state to grants. Thank you for joining us today, David.
Yeah, I'm David Coursen. I was at EPA between 1987 and 1999, and then again between 2004 and my retirement at the end of 2015. And now I've been doing volunteer work for the Environmental Protection Network, which is a group of primarily of former EPA staff who are working to advocate for the agency as it was previously understood.
No real retirement, huh?
Well, for about a year, yeah, but then after the administration changed, it just seemed as though it was important to do something. And I ended up actually, no one wanted to do budget, so I thought that was pretty important, and I knew nothing about it, so I've been doing that, and I'm now actually sort of an expert on budget, EPA budget.
And moving back in time a bit, could you give us a brief overview of your time at EPA as I believe it was the National Indian Program Coordinator? I'm particularly curious in your background and how you came to work in that particular area.
Well, actually, the way I came to work in it was that I was at the University of Oregon Law School, and one of the really top-notch people at the law school was Charles Wilkinson, who was very instrumental in the development of Indian law. He was one of the primary editors of Felix Cohen's Handbook on Indian Law, which is an authoritative treatise. He seemed to me to be a really outstanding teacher, so I took as many classes as I could from him, and that meant taking his course in Indian law, and then subsequently, as a sort of student-initiated thing, there was a second semester of Indian law, which he taught a seminar in, and that was more Indian law training than I think was available anywhere else in the country at that time. And then in addition, I wanted to do a writing project for him, and he steered me toward a topic that led to my having an article published on tribal reserve rights, and specifically on water conservation for fish protection, which became a very interesting, it's still kind of it's a cutting edge issue still, but I ended up doing a paper for him, which became an article on that. So when I was looking for work after law school, I looked at the Fifth Circuit in New Orleans, which had an opening, and it turned out that the director of the office had worked with Charles on the restoration of the Menominee tribe in Wisconsin. So because of that, he knew me, and when Charles vouched for my abilities, they hired me. So that was how I got to leaving. That was a 2-year position, and at that point I was looking in Washington, and I looked at EPA had some openings, and I applied there, and I was fortunate enough to be hired. There was a wave of hires in the late 80s, and I was hired partly in response to the reauthorization of the Superfund Act, and there was a lot of activity there, but they needed someone to work on the tribal issues, and gradually I sort of transitioned into that. There had been a desire to sort of provide Indian law expertise within the agency and within the Office of General Counsel, but as it happened, the real experts were in the regions, in regions 8 and 10, where they did a lot of Indian law work. And we realized that it was important to have some expertise in headquarters. And since I had done the work with Charles and had the interest in Indian law, I was offered that position and accepted it. And that became, as more and more, I initially did that in the context of grants because there were a lot of issues related to financial assistance for tribes as they were setting up environmental programs. And also there were a couple of issues in Superfund, which I won't go into except to say that they did have some prominence at the time. And so the result was that I was sort of naturally drawn into working on Indian law issues generally. And specifically, they decided that the way to team up some of the tribal rules for the water and safe drinking water and clean water programs was to have a team from headquarters work on them with experts from the tribal side, which would be me, and then also experts from the program side. And I worked on several regulations that implemented new statutory authority to treat tribes in the same manner as states under the two water acts. By that time, the way that sort of situation came up is that when the environmental programs were set, the federal environmental programs were set up, they did not contemplate the implementation of their programs on tribal lands. They just didn't think about it and didn't write it up. But EPA was faced with situations where it had programs it wanted to run in areas that were on reservations. And the question was what to do about that. And at that time, there was a lot of dispute over tribal authority. There was a lot of the tribes and states in a few cases were like the Hatfields and McCoys in terms of fighting over jurisdiction. So eventually EPA developed these regulations. So eventually EPA developed the Indian policy. It was the first agency to have a federal Indian policy. And the policy was to work with tribes on a government-to-government basis as partners in environmental management. Keep in mind, this was done primarily without any reference to tribes in the statutes, but as a recognition that EPA, as the environmental agency, needed to figure out what to do about environmental programs on reservations. Over time, the policy became sort of a beacon in federal policy toward tribes. It fitted in with the era of tribal self-determination, which was emerging in the late 80s. And it was essentially pointed the way, Congress thought, to addressing the role of tribes. And that was by authorizing EPA to treat tribes in the same manner as states, recognizing that in governance, the local authority would be a state, and in the context of reservations, that would mean a tribe. And so that's how the treatment as a state process, which is mandated in several of the major environmental statutes, but quite unpopular among tribes for the terminology, because tribes are very cognizant of the fact that they're not like states. They have a different kind of sovereignty. They have a direct relationship with the federal government that is a little bit, is quite a bit different from what the states have, at least in the minds of the tribal leaders. But that was a framework that was given to fold tribal programs into the federal programs.
And that leads into the establishment of the Indian Environmental Law Office, which I believe occurred while you were there. Would you be able to walk us through a bit? Because I understand there was quite a little bit of back and forth on which folks would be involved, which areas would be involved. Would you be able to lead us a bit step by step, some of the rationales and the process that went into it?
Yeah, sure. To the extent that they were apparent to me, which was not 100%. But yeah, the Office of Federal Activities had been sort of in the Office of Enforcement, had been the locus of the Indian program for a while. But at that time, the Indian policy came out of the Office of Federal Activities. But it really was not a very powerful office, and it wasn't really used to managing environmental programs. As things moved forward, the agency concluded that it had needed to do grants for tribes. And the difficulty was that they couldn't trace, they couldn't do the program grants for environmental programs generally required tracing the time, the work that each environmental person did and tracking it to a particular activity. And so you had an air specialist. But with the tribal programs, they weren't that sophisticated or that expansive. And the result was that they would have one environmental person doing a lot of things. And that did not match up very well with the EPA grant authorities. So a new grant program was created called the General Assistance Program. This was in 1991. And at that point, there then became a particular Indian program to administer, not just in the context of reviewing tribal application for air authority, or water authority, but rather for the tribes to actually operate a program. And there was a concern within some folks in the agency that the Office of Federal Activities did not see itself as an advocate for tribes, which sounds very noble and sort of impartial, except that if you know how the agency works, you will find that the other offices, like the Water Office or the Superfund Office, are not at all uncomfortable about advocating for their policy preferences. And so if you have the Office of Federal Activities as an honest broker and the Office of Water or Air advocating for their view, the tribal view is not going to emerge too strongly. So I think for various reasons, there was a desire to house the Indian program in general in some office that would be a powerful and effective advocate for recognizing and addressing tribal issues and needs. At different times, the Office of Federal Activities looked like it would try and keep the program. The Office of Administration and Resource Management, because of managing grants, looked like it wanted to have the program. The Office of General Counsel, which was addressing all these legal issues across various programs, looked like it might be a home for the tribal program. The conclusion was none of this worked very well. Let's set up a task force. And they got a woman named Martha Prothero, who had been a very senior manager in the water program. And although I think her selection sort of preordained the outcome, and she coordinated this intra-agency but rather large cooperative effort among various pieces of the agency to set up a tribal office. This became the American Indian Environmental Office. And that is, I don't know if that's still the name of the home of the program or not, but that was created, and it was designed to be a place where the tribal expertise and program management would be located. And they did not want to put it in the administrator's office because that looked like a sort of a boutique-y office, and those kinds of specialized offices tended to fall in and out of favor depending on the attention from the administrator's office. And it was considered very important that this be a powerful AA-ship that would be able to, that would have a stake in making the Indian program work. And it wouldn't just fall in and out of fashion. And so the idea, which made sense at the time, a practical matter, but it was conceptually, it was kind of unsound, was to put it in the water office, because that was where all the programs were, all the grants that were going out were mostly water grants. And at that time, there were not regulations for tribal air programs. So the programs that were being approved, and which was primarily for water quality standards, those were also through the Office of Water. So it seemed like a natural, if somewhat expedient home. And then over time, tribal advocates in particular thought this didn't really give sufficient deference to the sovereign authority of tribes. And it looked from that perspective, the international office, which was at that time a fairly new AA ship, seemed like a possible home for the program that would give it sufficient, the kind of stature that people felt it needed. So it became the Office of International and Tribal Activities, and that's where it's housed now.
In terms of interacting with tribes as sovereign nations as opposed to lesser components, I suppose.
Well, yeah, I think the idea was that structurally, in terms of the way that the environmental laws work, the treatment as a state process makes perfect sense. The tribes are filling the same shoes on tribal lands that states fill on state lands. There may be some differences. EPA has to do more direct program implementation. EPA may have to be involved with enforcement. But even so, the tribe is the governance body within the tribal areas, analogous to the state governance function elsewhere within states. And so it made sense from that perspective But I think tribes wanted to be recognized as sovereigns of a different sort. And the international office was a placing them in the international office was a way of recognizing that it is really a government to government relationship between tribes. It's not mediated by states, and it's not the same as states. The mediation by the states was something that the agency struggled with for a while, and that became sort of the jurisdictional conundrum that created some difficulties with implementing the tribal programs generally. But the formal mechanism was basically, there was no reason that the Office of International Activities couldn't implement that, because it wasn't really state and intergovernmental relations. It was a different kind of intergovernmental relationship. But I'm not sure that the program changed much in its new home, because by then I was no longer working in the area.
It sounds like a shift from more of a bureaucratic model to more of a diplomatic model. Would that be one way of phrasing it?
Yeah, I wish I had thought to say it that way. That's perfect. I think the challenge also at the same time was to figure out a way of getting these tribal programs up and running, getting programs on reservations that worked for the reservations. This was a constant challenge, and that was where the treatment as a state process became a bit of an albatross for the agency, because the agency decided that the best way to manage that and to manage issues about tribal jurisdiction was to require that tribes show that they had their own inherent authority as governments, and that the issue of tribal jurisdiction in reservations has been through several iterations over the last half century, and the Supreme Court has looked at these questions from a lot of different perspectives. But in general, the preference has been to respect the prerogatives of states, recognizing that tribes have the self-governance role. And so there was a constant sort of push-pull about authority over non-member activities on reservations. And ultimately, there's really only one way to do it. And I think everybody realized that you can't have two different authorities checkerboarded across reservations. You really need to have one authority, whether it's EPA or the tribe or the state, which of course can't do it because it doesn't have authority on non-Indian lands. So that was sort of the policy outcome that EPA came to with great difficulty, but it also became sort of a struggle with some states which didn't really want tribes to be, the tribal authority to be recognized in a formal way. And my first big litigation at EPA was South Dakota challenged a treatment as a state approval for a grant program for a tribe in South Dakota. They were very adamant that this was very important. They need to fight about it. And then they read our brief and they said, oh, that's all it is. It's just grants. Okay. And they dropped the case. So it was clear that it was more about form than substance in terms of what we were really recognizing with regard to tribal and state authority. And I think over time, people have recognized that water management has to be done by one entity, and that can't be the states. So it's the tribes, but that getting to that sort of policy answer legally proved to be quite difficult, and there was a lot of litigation over the problem. At one point, EPA did a very complicated showing to demonstrate that tribes had authority, required looking at all the lands and looking at various things, and that became very cumbersome. And it required a lot of developing of records and doing a lot of factual findings. The authority of tribes and states was a real bone of contention. And by the time that I came back, I'd left tribal issues in '94 and I'd left the agency. But when I came back, the big thing was that GAO, the Government Accountability Office, had done a report about the treatment as a state process and found that it was cumbersome, not very friendly to tribes, didn't work very well. And so things were not moving very fast. When I came in, the General Counsel had a mandate to address the TAS problem. And one way of doing that was to try and go through the backlog. At that point, there were tribal applications that had been pending for a couple of years while people sort of dithered. Ultimately, this did not benefit my career, but I did a lot of work trying to cut through some of these applications, do the work, develop the factual records that were minimally necessary to approve the tribal programs and get them approved. But people had been very nervous about that for a host of reasons, some of which had to do with anomalies in constitutional law. But that backlog was gradually worked down. But in doing that, I was less than discreet about the amount of impatience and exasperation I felt at how slowly and laboriously things had been done. And that didn't sit too well with the people who had done them that way, both in the regions, in one region in particular, and in headquarters. So it became very uncomfortable for me to continue working in that area. And I'd kind of done what I'd set out to do, which was to try and get some of these stale packages moving. So at that point, I went off and moved to constitutional issues that I was really interested in, working on environmental justice, which has become a passion of mine, and working on the AIR program, which I did by the time I left the agency. I was working full-time on AIR issues.
This is very insightful, especially for folks who've been working in federal Indian law are still pretty early in their career. And it sounds like there's a lot of frustration on the parts of the tribes and the parts of folks like you were working through that backlog. And a few years ago, there was some streamlining to the Clean Water Act regulations for treatment as a state. Was this part of the impetus for that?
Yeah, several people, several tribal attorneys and the general counsel were involved in a discussion about which way to go with the Clean Water Act and how to implement it, and whether to look at tribal authority, inherent tribal authority, that is authority that the tribe already has, or to look more at federal law and Congress's statement of a broad intent for how reservations would be managed. I think we came up with the wrong answer, and I was the leading advocate for this wrong answer. The other attorneys, they were more inclined to go in another direction than I was. But in any case, that was how we went. So there's a very exhaustive factual findings that have to be made to support approval of a tribal program. But the Clean Air Act was still being written at this time. And the idea that it was possible to delegate federal authority to a tribe, which had really no one had thought much about it until there was a reference in a very fractionated decision, the Brendale versus Confederate Tribes decision, where the court, for the first time, without explanation or background, referred to the Clean Water Act as a delegation of authority. That was what had made me nervous, and that's why I pushed back against it, and why other people who were stronger tribal advocates than I was agreed with me. But the Clean Air Act, there was no ambiguity. It was intended to be a delegation, and EPA interpreted it that way and implemented it that way. It saved an awful lot of disputes over who has authority over Farmer Brown's land, because Farmer Brown is a non-member, but he lives inside the reservation. With the AIR Act, it's very clear. So I think people got the idea that EPA needed to look more directly at the federal interest, what the federal legislation meant, and to get mileage out of that, and reinterpreted the Clean Water Act as a delegation, not an inherent authority statute. I don't really know what became of that, but that is, there was a proposal to do that, and it's certainly a much more efficient way of proceeding, and in my view, having sort of steered people down the wrong road. Jurisprudentially, a much sounder approach. It's much more consistent with the way that federal Indian law works, with Congress has plenary power in regard to management with tribal affairs. And so federal legislation is very, very powerful. And we got an example of that from Justice Gorsuch just a few months ago, with a decision that at a reservation that people thought had been disestablished hadn't been. And he looked closely at the words that had been used to establish the reservation, and he found that the words that needed to be used to disestablish it had not been used, and therefore, because of what the federal law did and did not say, the areas were still Indian, had never lost that character. And this is a big, a pivotal decision, a big deal, but a very powerful statement of the primacy of federal law in governance of Indian policy. So I'm hoping that people are taking it that way. It had nothing to do with environmental programs. It had to do with criminal authority, criminal jurisdiction. But it was very powerful, and emphasizing the preeminence of what federal law says about matters relating to management of reservations is just a really important insight. And it's a little different than what EPA was proposing to do with reinterpreting the Clean Water Act, but it's a part of the same, cut from the same cloth.
I want to go back just a little bit in terms of development of EPA. Was the Indian Environmental Law Office already established at that point?
Well, what happened was, as I said, there was really no sort of clearinghouse for environmental law expertise in headquarters. It was really just a function of the regions that had people who were working a lot with tribes and on tribal issues. Gradually, that evolved into a desire to have centralized expertise in headquarters. And that became, first of all, it became me, and then there was another attorney who had been away from the agency for a while who wanted to fill an analogous function from the regions so that there would be, instead of the headquarters attorney being the lead, there would be co-leads. That worked as well or as poorly as a lot of co-leads work, particularly when you have two ambitious people, each of whom thinks they should be the lead. That was really the reason that I stepped aside from doing tribal work after the Indian Environmental Office was set up. But the centralized law counseling and the centralized program office are two different things. And the Office of General Counsel, though, does have in the Intergovernmental Law Office, part of its responsibility is Indian law. And so when a question is a matter of Indian law, that office has the lead. When it's a question of managing the program or how the program works, the program office has the lead. And when it's primarily a function of working in a region with a particular tribe, the regional office, the regional counsel's office may have the lead. So you can see right away that for collegiality of that kind, you need a lot of trust and clarity. And that wasn't found in large measure when I was working on it before.
It's like a period of enormous change in terms of where management of these tribal programs are situated in terms of bureaucracy, but also in how the relationship between tribes and the federal government is just defined and what makes sense in terms of expediency and getting things done versus recognizing that relationship, that sovereign to sovereign relationship. It's a very interesting push and pull, as you mentioned.
Yeah, but I think the key thing probably is to recognize that when Congress wrote these laws, it may not have had much experience in describing a tribal role, but it knew what it wanted. And I think as EPA has looked more and more at that with the Clean Air Act and elsewhere, and assuming that imputing to Congress the desire to have a regime that worked, that's a big step toward looking at things that analytically I think are just as sound, if not sounder, than the inherent authority question. But the other thing that was going on with inherent authority is it was a constant political football between tribes and states. And the Supreme Court was responsive to that. And so there were various Supreme Court decisions that seemed to lean one way or the other. And so you ended up with a tribal approval process that shifted with the winds of Supreme Court jurisprudence. And that's a recipe for not necessarily disaster, but enormous uncertainty. And that was really what had paralyzed things at the time that I came back to the agency. The agency had been whipsawed with Supreme Court policy on tribes changing, and in addition with the trauma of this very unfortunate decision that was made in one of the regions. And so everyone was really gun shy about pushing ahead with tribal matters. I hadn't worked on it in 10 years. I was too dumb to know what the pitfalls were. So I just pushed ahead. People were comfortable to do that. It's just that they needed sort of to be led to the water, I guess. And there were issues about sort of working with general counsel and things like that. But I think the main thing was just recognizing to some extent that what was there was very problematic, and I don't think anyone really acknowledged, or in a formal way, that the program had been whipsawed because the Supreme Court had been reframing the law in ways that recognized that diminished the tribal role to some extent, and that recognized the transcendent importance of state citizens being governed by states. And that may be a good way to operate in other areas, but it's a very ineffective, it's a catastrophic way of trying to manage the environment, where the same rule will not apply to two people who are next to each other because one of them happens to be a non-member or a non-Indian.
Is there any example you're comfortable sharing that really illustrates that point?
I don't have an example so much as I think the way the conversation about tribal jurisdiction moved forward and was advanced most effectively was somebody created an anti-checkerboarding policy. You think about it, and that's in EPA's wheelhouse. That's about how environments can be managed effectively. And you know that checkerboarding won't work. And so you end up then just saying, well, we're not going to make decisions that lead to checkerboarding because we know that that's going to be a disaster for the environment. And so that is that sort of informed the approach EPA tried to take under its inherent authority model. But it was still different because you're getting these new Supreme Court decisions. I actually, at one point, I was in a conference in Denver about the Water Act, and I made some very ill-advised statement about how everybody recognized that tribes necessarily had authority throughout reservations. And somebody said, well, have you read your Supreme Court report today? There's a decision that doesn't seem to say that. And I, of course, had to say, no, I hadn't, but that was the Brendale decision. And that recognized that tribes had very measured and limited authority over non-members and on non-member lands. And that had seemed not to be where the law was going until it got there. And EPA, I don't think ever really adjusted to, well, quite recognized how to reconcile the direction of the law of inherent authority with effective environmental management. And that's why the Clean Air Act and the reinterpretation of the Clean Water Act, to the extent it's been done and implemented, makes so much more sense, because you can't just, there was one reservation that had 40 acres out of 4 million that were owned by non-members. And the agency decided that until it did an analysis of every one of those 40 acres, it couldn't approve the tribal program for the other million or so acres. That's not a good place to be when you have to fly spec questions of authority in that way. It might be a better area for the Bureau of Indian Affairs and their attorneys, because they work on Indian law all the time. EPA is not an Indian law agency. It doesn't have expertise in Indian law except what it has developed in the context of environmental law. So it's a very, very difficult position to put the agency in. And as the Supreme Court decisions change, what looks like a robust record might not look so robust. So you're constantly going back and forth and hemming and hawing. Meantime, the tribes, who know perfectly well that the law said treat tribes as states, and that they had their application in 8 months or 8 years ago, and nothing's moved, they're just tearing their hair out, or perhaps wanting to tear EPA's hair out, because it's so exasperating. It's very frustrating, because they have the job of doing the environmental management. When they can't move from step A to step B, it isn't getting done, and that's very demoralizing. And that's even leaving aside the larger project of Indian self-determination, which the federal policy has been to promote tribal self-determination. But if you can't protect your environment from pollution, it's hard to say you have much self-determination. So that's a part of the problem too.
From your perspective, where are we right now, as far as you've been paying attention, or at the point you ultimately retired from the agency, but where are we now when it comes to progress and what work remains to be done? It sounds like there's quite a bit needs to be done, but what would you really prioritize among that?
Well, I think there are two ways of looking at that. One is that the tribal programs need to continue to develop, and EPA needs, where the tribes can't manage comprehensive programs effectively, EPA needs to recognize the need to step in with direct implementation. But to the extent the jurisdictional sort of question, the threshold question, has been resolved, there are other questions that EPA has started to look at that I'm aware of indirectly. One is that tribes have reserved treaty rights to fish and to hunt. And what kind of role does that give the tribe in managing how the lands where they exercise those rights are regulated? Don't they have a strong interest, and isn't it a treaty-based interest? And so that's been an area that EPA has moved into. And then another area it moved into that may have been changed with a recent decision is looking at areas that are sort of heavily non-Indian in an area of the reservation where people think it has effectively been disestablished. Because what happened years ago is that reservations were created, and then over time policy changed to the allotment policy, which involved making all of the land private land, and tribal members then were given land and with the ability to sell it. And so you ended up with a lot of reservation land that went out of tribal hands. And when enough of that happened, it looked as though perhaps the reservation might have ceased to exist. And that's one of the origins of this idea of diminished reservations, which Justice Gorsuch found so troubling, and found that it could happen, but it needed to have, Congress needed to do it. It couldn't be done by acquiescence or practice or policy in a silent and informal way, where you just change a little here, change a little there, and all of a sudden, bing, the sovereignty's gone. That's not how it works, he said. And so that's going to be a big area where EPA will be looking. I think there, though, probably it won't be at the cutting edge, because I think the tribes themselves will work off this decision and recognize that it provides an opportunity to assert what really should be the tribal governance role in the areas that were set aside for tribes in exchange for the land, other lands that they gave up. They had lands that were reserved to them. And the idea that the reservation of those lands could be extinguished in some way it did happen when the lands were open to allotment. You had non-Indians who could become the full owners of the lands. But the idea that would diminish the reservation, it was very, made tribal sovereignty into something that's very fragile and federal. And it meant that Congress could change the status of tribes by indirection, without speaking up, without directly saying, this is what we're doing. I think Justice Gorsuch thought that was the wrong way to go. He's a textualist, and he said, we know what these statutes said. We go back and look at that and look at what else Congress has said in these areas. And if it hadn't said, it can disestablish, it has plenary power. It can disestablish reservations. But if it hasn't said that, it hasn't done it.
Quite a few challenges. And I see we're coming up with time. So David, do you have any words of wisdom for up-and-coming attorneys who are looking to follow in your footsteps, looking at EPA or just practicing in the field of federal Indian law and tribal law in general?
Well, it's a very exciting area, but it can be quite demoralizing, because the trend, when the Handbook of Indian Law was written, the trend seemed to be for courts to recognize and empower tribes. And as I said, it's considered the self-determination era. And now, subsequently, and I've never worked in it with a gaming tribe, but tribes have gotten enormous resources. I actually did work with one in Wisconsin, and it was really powerful lesson, because they were able to get they had a lot of money from gaming. They were able to show that how the activities they wanted to regulate would affect tribal life and would threaten it. And so it was the scientists and the experts were not all on the side of corporations and states any longer, but rather tribes have that expertise and that the power that comes with it. And so, but gaming is an area where it's misunderstood to some degree, because most tribes have not gained any power at all from that, because it's such a small dollar item, but a few have. And that means that some tribes are real players in a way that they had not been in the past. And so that's a change. And then the self-determination era, as it moves forward and as the agency gives meaning to the idea that tribes are to be treated, are to have the role that is like the role that states have elsewhere, as that becomes more real, that also is very powerful. But at the same time, you have, I think there's still a lot of resistance to tribal authority. Some might use the racism term. I'm not going to go there, but I am going to say that there's been a lot of resistance to it, and you can understand somewhat if someone has land that was inherited from a grandparent that's always been private land, and to learn all of a sudden that the tribe, which has a reservation in the general vicinity, has a more substantial regulatory role than it looked like it would have. That's quite a shock, and that can lead to all sorts of responses. But I think as the system matures, And if as the lines are clarified and as the practicalities are recognized, then perhaps things can work their way through. But I think it's very much, tribes are an element of the environmental justice movement, and we know that's sort of informing the nation's consciousness and conscience in a profound way. And I think you can't look at some of these tribal areas where there's no indoor plumbing and not see that these areas have been marginalized and bypassed, and that if environmental justice means anything, it means that the people who live there will be treated in a just and fair way and get their share of our nation's environmental protection resources.
And on that note, anything else you'd like to add, David?
Well, I think that sort of hits most of I guess the other things to keep in mind are that the grant program is still quite a large one, the General Assistance Grants Program, and tribes are still in the capacity building stage, and perhaps some of them always will be, that they don't have the resources to run an environmental program, but they need to be empowered to participate in running it. And this is particularly true with enforcement matters where tribes have limited authority to enforce laws, particularly against non-members. So EPA needs to step in and fill those gaps with direct implementation, with cooperative enforcement. But the theme has to be that this is a self-determination era and we need to empower the tribes. And I'd be saying that even if I had never heard of environmental justice. I did say it before I'd heard of environmental justice, because the policy toward tribes has wavered back and forth. But the current approach, which I think is the right one, is self-determination.
Absolutely. And we're still trying to figure out what exactly that means in so many ways.
Yeah, and how to bring it about in a meaningful way, because it's easy to, if you take it too far, you can set the tribes up for failure. But if you don't recognize the primacy of tribal concerns, then you're condescending and disempowering. It's a constant challenge.
As in everything in federal Indian law, there's a great deal of complexity and constant evolution, legal, policy, social, and it seems very likely that the sovereign tribes and EPA will be addressing many of these larger questions in the years ahead, which will certainly impact environmental protection in Indian country overall.
Yeah.
And
one final caution, I guess. I've expressed my views. Most of them are uncontroversial, not all of them though. And listeners are warned to take it with the requisite grain of salt where needed.
An excellent point. We will do that. Within so many things within this particular area of the law, it is complicated and it requires a good bit of subtlety. So many issues have many different dimensions.
Yeah.
Wonderful. And thank you so much, David, for being with us here today and to our audience. Until next time, this is Cynthia Harris with ABA Section of Environment, Energy, and Resources.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at www.americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.